Good morning. My name is Oliver Westmoreland. I'm a consultant for GSN Immigration. Last time we talked about UK partner visas. Just to recap, a partner visa is either a spouse visa, which is husband or wife, a civil partnership visa, which is same-sex relationship similar to a marriage, or an unmarried partner relationship, which is where a couple have lived together for at least 2 years. So a UK partner visa can be either of those three. The law about those three types is pretty much similar. The only difference is that an unmarried partner has to prove that they've lived for 2 years in a relationship akin to marriage, whereas with the other two categories, that isn't necessary. It sometimes happens that your partner visa application is refused. And of course, if this happens, it's a bit upsetting for you and you want to know what to do with it. First of all, let's think about what you can do. In a really bad and desperate situation, you can just give up. That may not be a good option for many people, but it is at least a possibility. Another option is you can apply again. Another option, which is quite an interesting one, is that you can make a complaint to the UKVI. You can say that your application was so badly handled that it merits a complaint and they should re-examine the decision. Another option is you can appeal. A partner visa refusal will create a right of appeal to the first tier immigration tribunal, which is a tribunal in the UK. It doesn't matter if you made your application from outside the UK or inside the UK, the right of appeal exists to the first tier tribunal. Now, these different options have a different legal and psychological landscape. If you want to give up, well, that's the end of it. If you want to fight, if you want to challenge, as I said, if the decision was made so badly, you could make a complaint to the UKVI. However, you have to be careful about something. If you are going to appeal, if you are thinking of appealing, there's a deadline. If the application was made in the UK, the deadline to appeal is 14 working days from when the decision was sent. If you're applying from outside the UK, the deadline is 28 calendar days after the decision was received. If you're going to make a complaint and the complaint is unsuccessful, you may lose the deadline to appeal. So it might therefore be a sensible idea to make a complaint and to lodge an appeal. Very importantly, with partner visas, there is no administrative review. Administrative review exists for working visas and various categories, not partner visas. So if you're going to take the legal route, the appropriate legal route is appeal. The differences between in-country and out-of-country for appeal are really fairly slight. As I said, the deadline is different, but apart from that, most of the procedure is the same. What happens first of all, when you receive your refusal decision, is you or perhaps your lawyer will lodge a grounds of appeal. This really means that you are applying to the first tier tribunal to appeal against the decision. There's a form that has to be filled in, and also you or your lawyer have to write a grounds of appeal. A grounds of appeal is a legal argument that purports to say why the decision was wrong, in what legal way the decision was wrong. It's not always completely detailed, but it does have to have the gist of why you are appealing against the decision, or why your partner is appealing against the decision, why the decision was wrong. These papers get sent to the tribunal within the deadline, hopefully. Now, if it happens that you're unfortunately late, you can ask them to extend time, but this isn't always successful. It's a very, very good idea to make sure that you lodge your appeal within the deadline. I've been talking so far as though there's an important choice between doing it yourself and getting a lawyer to do it for you. Well, there is. I would like to say, now obviously I'm a lawyer, so I'm in a rather biased position, but I would like to say that it might be a very good idea to get a lawyer to do it for you. Appeals are generally complex. The law about partner visas, which comes in the dreaded Appendix FM of the immigration rules, is very complex. You might want to instruct a lawyer to do it for you, not because you may not be at all stupid, you may be extremely intelligent, but the thing is about an immigration lawyer is that they do this kind of work day in, day out, week in, week out. They probably, or they should know what they're doing. They should do the job competently. Now, if it happens that they don't, then you had some legal recourse against your lawyer, but hopefully that won't happen. So you really might want to consider getting a lawyer to do the work for you. I explained about lodging the grounds of appeal, which is what it is. This isn't a very complex procedure, really. As I say, the grounds of appeal sets out the reasons why you say the decision is wrong or unfair or unlawful. Here comes a very slight difference between appealing in country and appealing out of country. If you appeal in country, certainly in my experience, the tribunal receives the papers and they process the case. There is a fee to pay, which for an oral hearing is £140. They take the fee, they do the process, and then eventually, one day, you will receive a notice of hearing, which tells you when the hearing is going to happen at the tribunal in front of an immigration judge. Out of country, there is one very slight difference. Once the grounds of appeal has been received by the tribunal, they send it to the British Embassy or the British Diplomatic Post who make the decision. The entry clearance manager in the British Diplomatic Post looks at the decision and he decides whether the person who makes the decision, who would be entry clearance officer, who's a junior sort of grade, he or she will decide whether the entry clearance officer's decision was correct. If he or she thinks it was correct, then you get a letter from them saying, we think the decision was correct, sorry, we're not changing. If the decision, the ECM thinks the decision was wrong or unlawful in some way, so much so that it should be overturned, at that stage, the refusal decision can be withdrawn and the decision can be changed, and you or your partner will get the visa. I don't think this happens in country. I've never seen it. I think this is something that happens particularly with out-of-country applications. So, with out-of-country applications, it could be, if the refusal decision is very weak, and if the entry clearance manager realises it's very weak, which doesn't always happen, but if the entry clearance manager realises that the decision is really weak, the decision could be withdrawn and you or your partner will get the visa without any more trouble. If that doesn't happen, then matters progress to the next stage. The tribunal, as I say, will send a notice of hearing to you or to your partner saying that there will be a hearing at the tribunal on a certain day. Now, there's one other thing that I must tell you. You don't have to have an oral hearing in front of a judge. You can do the whole process on the papers. The judge just reads the papers. He doesn't have to meet you. He doesn't have to see you. Some people, in some cases, prefer that. Lawyers would probably generally advise that an oral hearing is better, but sometimes there are certain circumstances some people would prefer the paper hearing. If you do have a paper hearing, there's one small advantage. The fee is only £80, not £140, which might be important to some people. So either a paper hearing or an oral hearing. If it's a paper hearing, it just happens and you just wait for the result. If it's an oral hearing, matters are a bit more complicated. You or your lawyer get the notice of hearing. You and your lawyer, and here you really might need a lawyer, put together a bundle of papers to send to the tribunal. The bundle of papers includes probably you and your partner's witness statement about the case. It will probably include any papers, any evidence that you want to have to support your argument. There's no particular limit to what sort of things you can put in your bundle of papers. Anything that's going to be helpful to the case, to strengthen the case, should be included in the bundle. You or your lawyer will make 2 copies of the bundle. One will be sent to the tribunal, one will be sent to the Home Office. Then the day comes for the hearing in the tribunal. As I say, the tribunal is in the UK. There are various centres throughout the UK, in London and elsewhere. You will go to the tribunal as a witness, no doubt. If your partner is in the UK because they've applied in country, then probably they should go as well. If your partner is outside the UK, it's going to be rather difficult for them to come to the tribunal, but they will nonetheless have provided a witness statement. Any other witnesses that you think could be useful to your case, you should get them, you should persuade them to be witnesses in the hearing. The hearing will be held in front of an immigration judge. It's important to understand that the immigration tribunal is not a court, it's a tribunal. It's a relatively informal procedure. It's not like the American court dramas that you might see on television. People are not wearing wigs and funny clothes. It's normal business dress. It's an informal hearing, but it's not completely informal because the judge wants to get to the bottom of things, wants to understand all the evidence. You have to give evidence for maybe 10, 15, 20 minutes. You or your partner might have to give evidence for a relatively short period of time. A lot of the time in the hearing will be devoted to speeches or speaking from a Home Office lawyer who should be there, your lawyer, who, if you have instructed one, who will be representing you at the tribunal, and the judge can speak when he wants, when she wants, say what they want pretty much. The way that the hearing is conducted is entirely at the discretion of the judge. It's not quite like a court with a strict formal routine. It's all a bit more flexible. Different judges do hearings in completely different ways. After all the evidence has been given, the judge may have some questions of their own. Some judges have a lot of questions, some judges have fewer questions. The judge will ask the Home Office lawyer to make a kind of a closing speech to say why the appeal should be dismissed, i.e. fail, why it should fail. Home Office lawyer always starts off with something like, I support or maintain the decision that the Secretary of State has made because blah, 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 blah. When that's all been done, the judge will then invite you or your lawyer to make a closing speech to say why the appeal should be allowed, why the appeal should be successful. Now, you or your lawyer always have the last word. Now, some people think that having the last word is best. You will always have the last word at the tribunal. When this has been done, one of two things might happen. The judge might say, yes, I'm quite persuaded that your case is strong. I'm allowing the appeal. Congratulations. This happens in a minority of cases, I would say, and it's only going to happen if the judge is very, very sure that your appeal is strong enough to win. If the judge is not really sure, he or she won't make a decision, and if the judge isn't sure at all, they won't make a decision. The judge will say, I'm going to think about this, and you will get a written decision within, they usually say 6 weeks, but hopefully it's a bit quicker. So one of those two things can happen. If you don't get a positive decision from the judge at the hearing, it doesn't mean you've lost. It doesn't mean that you've got a weak case. Some judges don't like doing it at all. It's just a kind of a bonus, a gift to relieve people's anxiety. A nice judge will allow the appeal at the hearing if they're sure it's a really strong case. So the judge goes away and makes a decision, and within a few weeks, usually within 1 month, I would say, in my recent experience, you get a detailed written decision from the tribunal, which is called a determination. This can go over several pages. It will set out the judge's decision in some detail. Judge should be very careful to write a properly detailed decision because the decision can be challenged. If you lose the appeal, you may have the right to challenge the immigration judge's decision at the upper tribunal. The upper immigration tribunal is the higher tier, higher than the first tier tribunal. If you or your lawyer, and here again, this is the sort of situation where a lawyer can be very helpful, if you or your lawyer can determine an error in the decision, the error has to be material and important. It might be, for example, a misreading of the law. It might be a gross error of fact. It might be something else, but if it's something which is arguably an error, it doesn't have to be certainly an error, but arguably an error. And if that arguable error would have affected or might have affected the decision, then the upper tribunal might decide that the first tier tribunal's decision was maybe not wrong, but arguably wrong. If that happens, the upper tribunal can change the decision, or they can send the decision back to the first tier tribunal and ask the first tier tribunal to hear the case again, but this time with a different judge. Either of those could happen. Now, this sounds nice because it gives you a second bite of the cherry. However, the Home Office also has a second bite of the cherry because it has to be fair, doesn't it? So if the Home Office is not happy that your appeal was successful, the Home Office can try and change the decision with the upper tribunal in exactly the same way. So this is why when I say to people, they get a successful appeal decision, they think, wow, I'm going to celebrate. You can celebrate a bit, but don't celebrate too much and don't celebrate too completely, because the Home Office can challenge a successful appeal decision if they think there's an error in the decision. The upper tribunal is like a kind of a referee in a football match. It's not on your side, it's not on the Home Office side. If either party points out what looks as though it might be an error, then the upper tribunal is impartial, and it might either, as I say, might change the decision or might send it back to be made again, but this time on the correct legal basis. Now, this all sounds quite complicated, and indeed it is quite complicated. It's a very brief outline. There's a lot more complexity than this. In GSN, we have got a good few years' experience in dealing with appeals, and if you have a refusal decision, we will be able to give you good advice. We will be able to give you the good advice about what is the right thing to do. Should you appeal? Should you give up? Should you make a complaint? Sometimes there is very good grounds to make a complaint, but as I say, you have to be careful about not losing the right to appeal. The reasons for the decision might be very important for you to decide whether you want to appeal or not. The fact is that an appeal process takes a long time. It's not just weeks, it's months. Your visa application is refused with a very horrible and unfair decision. You lodge an appeal. The Home Office doesn't withdraw the decision. Now, it sometimes happens that especially in in-country appeal, the Home Office withdraws the decision on the same day as the appeal hearing. This has happened to me. I've been sitting in the office one day and I get a phone call, Home Office, hello, we're withdrawing the decision for the appeal hearing tomorrow. So, even if the Home Office does decide to withdraw the decision, which can happen either in-country or out-country, certainly with in-country, they can withdraw the decision at the very, very, very last moment. So in that sort of situation, you don't save any time at all. It can take you months and months and months and months. And I think most particularly with an out-of-country application, because those go to the back of the queue, they want to deal with people who are already in the UK first. So the time factor is important. Your relationship may be under strain already. With a few more months added onto it, it might make things a bit worse. There is the time factor. There's also another factor. Let's say if the refusal decision is on some sort of rather technical basis. You didn't submit quite the right documents to prove your financial situation. It looked as though probably you meet the rules, but you didn't submit all the right documents. Appendix FM is very, very strict. You don't submit the right documents, your application gets refused. There's no way around it. If you have a situation like that, it might be a sensible decision not to appeal. Not because you weren't right. Maybe you could do the appeal and maybe you could win because you could provide more documents, but maybe it's a sensible decision to forget that and make a fresh application. Fresh application is definitely going to be quicker than an appeal, and you could use the refusal decision as a useful learning process. Is what happens sometimes. People perhaps try to do the application themselves and they don't quite understand the rules because they are formidably complicated. They don't submit quite the right documents. They make a fresh application and take on board the learning from their previous refusal. That's not the best way of doing things, but it does happen quite frequently. Sometimes, though, you get a refusal decision about unmarried partner application. They say, we don't really believe that you've been living together for 2 years, your evidence wasn't good enough. This is a bit of an in-between situation, because sometimes people can't get good evidence that they've been living together for 2 years. If they try to make a fresh application, they couldn't provide better evidence. In a case like that, you really might want to do an appeal. You really might want to go in front of a judge. You might want to give your friends to be witnesses. You might want to try and convince a judge that indeed you are, well, first of all, in a genuine relationship, and you have been living together for 2 years. Judge is a human being, more or less. He's sitting in the same room as you. The judge is allowed to take into account whether he thinks people are honest, whether they're credible witnesses. If you're making applications to the Home Office can't possibly know whether you look like a credible witness. They haven't seen you, they haven't seen your face, they haven't seen your demeanour. Judge in a tribunal hearing is entitled to make assessments based on that sort of thing. This is the sort of situation where lodging an appeal, having an appeal case, can be the right way forward, because otherwise you may never win, unless maybe wait for another year or so, get a bit more evidence of living together. That's probably not going to be a good option for most people. So a case like that is fairly borderline. The worst case is where you've been accused of deception. You've been accused of submitting fake documents. You've been accused of lying. In a situation like that, you really might want to take out an appeal with the tribunal, because if you make a fresh application, it's extremely probable that it's going to be refused on exactly the same basis as the previous application. You can't wipe out the past, not with the Home Office, you can't anyway. If you've been accused of doing something in the past, a few months ago or a few years ago, that doesn't come off your record. It's on your record pretty much forever. If you've been accused of deception or dishonesty, you really might want to do an appeal before an immigration judge, convince the immigration judge that you've been honest, the document wasn't fake. This can be a good idea, not just for this reason, for another reason. Home Office are very good at making allegations of deception. They're not very good at following them up. The Home Office trips itself up. The Home Office gets mixed up. Occasionally they forget to send a lawyer to the appeal hearing. If you've been accused of deception or dishonesty, very possibly lodging an appeal is a very good option. As I say, these issues are really quite complex. This is a very short and brief summary, but if you have had a refusal and you want some help, we at GSN Immigration, we do our best to help you.